Section 110 of Evidence Act, the burden of proof as to ownership. Section 110 of the Indian Evidence Act of 1872 speaks about burden of proof as to ownership. This section says that when a person is in a possession of anything as a owner, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. The principle behind this section is that possession is the prima facie evidence of a title, and anyone who intends to oust the possessor must establish a right to do so. The principle will not apply if the possession is derived by force or a fraud. The term possession in this section has to be understood not as a juridical possession but as an actual present possession. This section gives effect to the principle that possession is prima facie evidence of complete title. Anyone who intends to oust the possessor must establish a right to do so. This is to be presumed from the lawful possession until the wants of a title or a better title is proved. The principle of the section does not apply where the possession has been obtained by fraud or force. The term possession in this section is to be understood as opposed to judicial possession and to denote actual present possession. A person in possession of a land without a title has an interest in a property which is heritable and good against all the world except the true owner. An interest which, unless and until the true owner interferes, is capable of being disposed of by the deed or will or execution sale, just in the same way as it could be dealt with if the title were unimpeachable. The Madras High Court held that as against a wrongdoer, the prior possession of the plaintiff in an account of ejectment was a sufficient title, even if the suit be brought more than 6 months after the act of dispossession complained of, and the wrongdoer could not successfully resist that suit by showing that the title and the right to possession were in a third person. It was immaterial, however short or recent the plaintiff possession was. The Allahabad High Court held that Section 9 of the old Specific Relief Act did not debar a person who had been ousted by a trespasser from the possession of immovable property to which he had merely a possessory title from bringing a suit in ejectment on his possessory title after the lapse of 6 months from the date of his dispossession. Under Section 111, a proof of good faith in a transaction where one party is in a relation of active confidence. The principle of the rule embodied in this section, which was called the great rule of the court, is he who bargains a matter of advantage with a person placing confidence in him is bound to show that reasonable use has been made of that confidence, a rule applying to trustees, attorneys, or anyone else. Where fiduciary or quasi-fiduciary relationship exists, the burden of sustaining a transaction between the parties rests with the party who stands in such relation and is benefited by it. The plaintiff, having been entirely in the hands of a defendant, would be destitute of the means of proving affirmatively the malafide of the transaction, whilst the defendant in such a transaction may fairly be subjected to duty not only of dealing honestly but of preserving a clear evidence that he has done so. In such cases, it is seldom, if ever possible, to prove a specific act of deception or of exercise of authority amounting to moral coercion. Yet, the risk of abuse is obviously great. The law therefore reverses its usual rule of evidence in dealing between a man and man. Commonly we do not presume without specific indications. If there is anything contrary to good faith in a transaction which on the face of them are regular, but this is the rule as between equals, persons who are capable of dealing with one another, or as the accustomed forensic phrase grows, at arm's length. When one party habitually looks up to other and is guided by him, he can no longer be supposed capable without special precaution of exercising that independent judgment which is requisite for his consent to be free. A person who claims to have acted under a bona fide belief must himself appear as a witness to establish his claim. The version of other person in that respect may not be sufficient. Active confidence, these words indicate that the relation between the parties must be such that one is bound to protect the interests of the other. This had been held to apply to a trustee, an executor, an administrator, a guardian, an agent, a minister of religion, a medical attendant, an auctioneer, an attorney. In a case of deeds and power executed by Padanasin ladies, it is requisite. In a case of Padanasin lady, the law throws. In a case of deeds and powers executed by Padanasin ladies, it is requisite that those who rely upon them should satisfy the court that they had been explained to and understood those executed themselves. In a case of Padanasin lady, the law throws around her a special cloak of protection. It demands that the burden of proof shall in a case rest not with those who attack, but with those who found upon a deed executed by her, and the proof must go so far as to show affirmatively and conclusively that the deed was not only executed but was explained to and was really understood by her. Even in cases where a Padanasin lady had independent advice, the court will scrutinize the transaction very close to see that it is a fair one. Her free and intelligent consent to a transaction is necessary. The rule of special protection of Padanasin, old and illiterate woman, should not be applied in each and every case, but should be applied in the light of the facts of each case. Under section 112, presumption as to certain offences. The section is based on the principle that when a particular relationship such as marriage is shown to exist, then its continuance must prima facie be presumed. Under the section, the fact that any person was born during the continuation of a valid marriage between his mother and a man, or within 280 days after his discussion, the mother remaining unmarried, shall be conclusive proof of that he is a legitimate son of that man, unless the party who had no access to each other at any time when he could have been begotten. Evidence that a child is born during wedlock is sufficient to establish its legitimacy and shifts the burden of a proof to the party seeking to establish contrary.